Welcome to the League of Women Voters of Snohomish County Forum for Candidates for Snohomish County Superior Court Judge, Position 17. I'm Valerie Cole-Kelly, a member of the League. This forum is being live streamed to our League YouTube channel. To those in the virtual space, thank you for joining us. We refer to these primary forums as virtual doorbelling. We will ask a short series of questions, the kind of questions you might ask of a candidate who came to your door. Our questions are designed to give you a clear idea of each candidate's experience and the issues they believe are important to address. A recording of the forum will be available on the same YouTube channel for later viewing. Let me provide some background on the position. Superior Court judges serve 4-year terms. Superior Courts are organized by county into 31 judicial districts. Superior Courts hear felony criminal cases, civil matters, divorces, juvenile cases, and appeals from lower-level courts. Candidates for Snohomish Superior Court Judge, Position 17, are Mary Anderson, Jody Cloutier, and Patrick M. Moriarty. The League thanks all the candidates for running for office, for their willingness to serve the community if elected, and for participating in this forum. It is the policy of the League of Women Voters to be nonpartisan. Therefore, we neither endorse nor oppose candidates or parties. We do take positions on issues which we have studied and on which we have reached consensus. The rules for forum participation were sent ahead of time to all participants, and they have agreed to engage in respectful communication throughout the event. Let us briefly explain the question and answer period rules, and then we can begin. I will pose the questions and will clearly state the amount of time allowed for each answer. We are using a countdown timer visible to all candidates, and time limits on answers will be strictly enforced. I will change the starting order for each question, alternating candidates in the starting position to ensure a fair sequence. The order for the first question will be Mr. Moriarty, then Mr. Cloutier, and then Ms. Anderson. Let's begin. Candidates will have 2 minutes to respond to this first question, and it is, what is your general judicial philosophy or approach? Again, 2 minutes. What is your general judicial philosophy or approach? Mr. Moriarty, you're first.
Thank you. I have been serving as a judge for the last year. I have 17 years of judicial experience as a judge pro tem. I believe that every person who appears before the court deserves to be treated with respect. It is imperative that people believe that they are receiving a fair and impartial hearing by any judge who is sitting on their case. I make it a point to make sure that the parties treat each other with respect, and my philosophy with regard to handling cases is to make sure that the type of case that is before me is one that the parties are prepared to address. And I have dealt with every type of case that comes before Superior Court. I have been on civil cases involving personal injury, involving trusts, estates, parenting plans, divorces, and my judicial philosophy is to make sure that the parties understand the nature of the proceeding before me, are able to address the issues in the case that need to be decided in a clear and concise fashion. And I make a decision based upon the law, applying the statutes, looking at the case law, and making a decision that is based upon the arguments of counsel and applying the law to the facts in a way in which the court can make a reasoned decision as to the problem that the parties are having. So thank you very much.
Thank you, Mr. Moriarty. Mr. Cloutier, same question, 2 minutes.
Thank you, Valerie. My judicial philosophy is one of preparedness and respect. I think it's really important that that everyone who comes before the court is treated with dignity and respect, and that we're doing our part to make sure that we're delivering a just result. And there are a few parts of that. First, it's important to treat each person as an individual. People that come before the court have all sorts of unique circumstances that brought them, whether we're dealing with a car accident or a criminal matter or even a divorce. As a Superior Court judge, we're hearing all of those. And we need to understand each person's circumstances so we're making a decision that makes sense, that comports with the law, and that we know what questions to ask them. The next part is simple preparation. In my practice, I often see judicial officers that just aren't prepared. That's not fair to the litigants, and generally it doesn't serve the public. So I believe in being prepared, reading the materials, briefing myself on the law, and really making sure that when I come out to the courtroom, I'm ready to hear that case. Finally, additionally, it's important to ask questions. I have a pretty strong reliance on asking questions, making sure that I understand the issues. And finally, it's really important to explain my reasoning. I've heard from a lot of voters in the county that they don't always understand how decisions are made, especially when it comes to criminal matters. And I think we could do the public a better service by being more willing and taking the time to explain how we reach the result, whether that's criminal, a car accident, or anything else that comes before the court. And I think those are all important, and I think the people of Snohomish County would agree. Thank you.
Thank you. Ms. Anderson?
Thank you so much. First and foremost, it's all about transparencies. As judges, we must maintain the highest standard of fairness in our legal system. The judicial system needs to be open to the community to ensure each person who appears before the court understands the court and its ruling, to ensure everyone is heard and seen before the court issues its ruling and the laws and the Constitution are upheld. I will be that bridge of understanding between the community and the judicial system, and my courtroom will be open to the people, and I will educate the community on the role of a judge. Additionally, equal access to justice is important. A judge's role in enhancing equal access to justice has 3 components. First, a judge must lead with kindness and compassion, with fairness and equity at the top of her mind, administering the law and court rules equally for all, while recognizing that all are not equally equipped to understand what the law and rules require. Also, balance the kindness and compassion with the accountability of the accused. Second, in their professional capacity outside of the courtroom, a judge should always encourage community involvement and organizational efforts aimed at enhancing equal access to justice. Third, in their personal capacity, a judge must remain humble as we serve the community and continue to learn regarding access to justice issues and efforts to address them. Thank you.
Thank you. For this next question, candidates, you'll have 90 seconds to answer. Timer, could you please change the clock? Our second question is, what qualifications and experiences make you a good choice for this position? 90 seconds. Mr. Cloutier, you're first this time.
Thanks, Valerie. Honestly, I'm the candidate with the most diverse background. Many of you probably seen the show Law and Order. It starts with, here are the police, dum-dum. Here are the courts, dum-dum. Well, I'm the law. You can actually call me probably the Law and Order candidate because I've been both sides of those. I've been a police officer. I've been a lawyer. I've seen the problems we face in society from both sides of the coin. Beyond that, I'm an adjunct professor of law at Seattle University. I spent almost 20 years in technology before going into the legal profession. It seems like I've had just about every career out there. And in that job, I worked to make the internet safer for families and children. I've also spent that family and children theme sort of has followed me throughout my life. My practice is really a domestic violence focused practice. And I started that to help kids and spouses survive the kind of situations like I had to survive when I was growing up. And all of these experiences allow me to come before the court and understand what many people who come before me are going to. And considering that more than 50% of all cases in the Superior Court of Family Law cases, don't we need a judge who knows those issues from all sides? I think we do. Thank you.
Thank you. Ms. Anderson, your turn, same question.
As a judge pro tem and a trial attorney, I have the breadth of knowledge, which includes criminal and civil, judicial, trial, transactional, and appellate experience. I am the only candidate that has federal, class action, and appellate experience in the Supreme Court and Court of Appeals. Also, I am the only candidate who has successfully argued before our state Supreme Court in Lyons v. U.S. Bank National Association. It was my legal analysis that led to protecting the rights of Washingtonians from overreaching trustees' foreclosures now and in the future. Additionally, I have experience in real estate and the mortgage industry. I have owned and operated a mortgage brokerage firm. I was a licensed realtor, and I have over 25 years experience as a business owner. It was during this time dealing with legally binding contracts on a day-to-day basis that re-energized my calling to pursue a career in law. Thank you.
Thank you. Mr. Moriarty, what about you?
Thank you. I have 22 years of judicial experience. In my years as a public defender, prosecuting attorney, judge pro tem, I saw firsthand the devastating toll that drugs such as fentanyl and substance use disorder have had on individuals, families, and the whole community. I have helped hundreds of clients seek treatment for these illnesses, as well as mental health disorders. I have worked with the Snohomish County Juvenile Court Drug Court Program for 10 years, helping hundreds of kids combat addiction, and I'm familiar with the evidence-based programs that are utilized by the court in addressing these issues. I served for 4 years as a Snohomish County Superior Court Commissioner. I dealt with family law cases, people that were involuntarily committed to hospitals in need of behavioral health treatment. I have seen the number of unrepresented people in our community increase exponentially because of unaffordable legal fees and inability to hire lawyers, language barriers. I was part of the Superior Court's efforts to keep the court running during COVID-19. I served on committees where this was a situation where the court needed to continue running, building the plane when it's at 30,000 feet. I've seen the problems of this community firsthand, and I've addressed every type of case that comes before it.
Thank you. Now, we'll have 90 seconds for this third question, which is this. If, as a judge, you observed bias, unfairness, or other discriminatory acts by attorneys, parties, witnesses, or observers in your courtroom, how might you deal with such acts? Again, 90 seconds. Ms. Anderson, you're first this time.
Thank you. As a judicial officer, we have an obligation under our judicial canons to call out biases. In fact, the Washington State Supreme Court wrote a letter to the judiciary dated June 4th, 2020, to call out any type of systemic racism that actually occurs in court. There was a case that came out. It was Henderson. The case name is Henderson. This was a case where the jury and the judge was being completely biased to a Black defendant and a Black trial attorney. But our state Supreme Court had the judicial courage to call that out. So as your next Snohomish County Superior Court judge, I will actually have that same courage to call it out. I will always call it out because it's the right thing to do, even though it may not be popular. We must uphold the integrity of our judicial system. Thank you.
Thank you. Mr. Moriarty, how would you answer the question?
Thank you. I agree that it is very important that a judge control the courtroom to make sure that all parties are treated with respect and dignity that everyone deserves. I've had situations where parties have become unruly, where they've name called, they've used racial epithets, they have made derogatory comments on the basis of a person's gender or identity. I have been a member of our Cultural Advisory Committee, where I continue today, and we address issues of diversity, equity, and inclusion to make sure that the judicial system is operating in such a fashion that people do not feel like they are barred or that they will be mistreated if they come within the courtroom. It is imperative, if somebody is acting in that fashion, that the court take control of the situation. That may be as simple as taking a break to make sure that parties calm down. It may be instructing a person to have a seat. It may get to the point where you have to call in a marshal that is going to have to obtain order within the courtroom. But it's imperative that the court do so. And then if the party has been to the point where they have disrupted the proceedings in such a fashion, it may be a situation where you may have to hold a contempt proceeding with regard to their behavior.
Thank you. Mr. Cloutier, your turn.
Well, Valerie, I believe in see something, say something. The fact of the matter is, if we don't aggressively be on the lookout for bias when we're in the courtroom, we're going to put people in a situation, people who may already feel uncomfortable about coming to our courts for help, in a position where they're more reluctant to come to the courts because they don't think they're going to be treated fairly. That's absolutely unacceptable. I had actually an example of this as I was sitting as a pro tem commissioner. I was in ex parte, and a woman came before my court and began making derogatory comments about LGBTQ plus people. I stopped the proceedings cold and told her this was not going to happen in the court. I was going to kick her out of the courtroom, and we were simply not going to do this because that kind of language is absolutely uncalled for and unacceptable in a court of law. I've also had this in my personal life. When I was younger, my sister is an African-American woman. I had a friend who was a very good friend of mine at the time, in front of me, call her the N-word. I was so outraged. My best friend. I shouldn't have done it. It's wrong. But at the time, I punched him in the face and knocked him to the ground. I didn't speak to that man for over 20 years. I was so upset. And later on, he found me and apologized. So I've seen this firsthand, and I absolutely don't tolerate it. And I don't believe anyone should.
Thank you. Okay, timer, please note that candidates will have 60 seconds for our final question. And it is this. Please tell us something about your life experience that might surprise or intrigue voters. Again, only 60 seconds this time. Mr. Moriarty, you're first.
All right, thank you. Well, I started practicing law in 1991. I started as a public defender where I worked for approximately 8 years before leaving to try my hand at private practice. I never thought that I would become a prosecutor. However, my wife and I had a daughter who was premature and ended up needing to stay at home due to some significant medical issues. That caused a great deal of medical bills, which required my wife to come home and stay with our daughter and me to find a job which would provide medical insurance for the family. I then worked as a prosecutor for a period of 2 years. I'm certainly glad that I did. I met some very wonderful people there, and it gave me a great deal of perspective that I didn't get when I was just a public defender. And it has made me a better judge today, where I see both sides of an issue. I have empathy for both parties, and I'm able to judge a case in a much more fair manner.
Thank you. Mr. Cloutier.
Well, Valerie, I was homeless. I came from a broken home, was ravaged by abuse. My mother was a victim of domestic violence. I was a victim of domestic violence. I worked full-time all the way through high school. I was told by a high school vice principal twice, why don't you just drop out? But you know, I had a strong North Star and a strong work ethic. I was able to pick myself up and make a great life because I believed I could do it and I believed in myself. Now I've worked myself up to where I'm a pro tem commissioner in the Snohomish County Superior Court. And had I taken that vice principal's advice, I probably would have been someone that society forgot. And I've carried that with me. I'm determined never to let people be overlooked in my courtroom. I might dismiss your case, but I will never dismiss you. And I think we can all agree that's critical.
Thank you. Ms. Anderson.
Thank you. My husband, James, and I met 36 years ago, and we are still, yes, happily married. He and I raised a beautiful daughter, and we are proud parents of a Navy veteran who served our country. Practicing law is my third career. I enjoy riding a bike when I can actually find time. I completed the Seattle to Portland bike ride, which is well over 200 miles. And I'm just asking that you elect Mary Anderson for judge, the people's voice. Everyone deserves a good judge.
Thank you. The League appreciates these candidates for joining us and for running for office. A recording of this forum and others will be available on the League of Women Voters of Snohomish County website and YouTube channel. Find links at lwvsnoho.org. That's lwvsnoho.org. We encourage you to explore additional information about these and all candidates. The Snohomish County voter pamphlet will be mailed to residences starting July 12th. Primary election ballots will be mailed starting July 13th, and Election Day is August 1st. Please be a voter. Thank you to our League Candidate Forum team, and special thanks to Dave Moon and the Sultan School students at turkpride.tv who made this live stream possible. And of course, thank you all for joining us. This concludes our Candidate Forum.